by Craigneuk Homes against the decision by the North Lanarkshire Council to refuse an application seeking to seek a modification to an existing Section 75 agreement in respect of contributions for play, community facilities and education in relation to a residential development at land east of Wellington Street, Craigneuk in Wishaw. I'm Trudy Craggs and I'm a reporter with the Planning and Environmental Appeals Division of the Scottish Government, which is known as the DPEA, and I've been appointed to determine the appeal. This is a virtual hearing session and is being broadcast live. It will be stored as part of the DPEA website archives and will be capable of repeated viewing. By participating today, you are consenting to being filmed. You're also consenting to the use and storage of these images and sound recordings, and of any images or information pertaining to you contained in them, for webcasting and training purposes, and for the purpose of keeping historical records and making these records available to the public. Further details on our privacy policy can be found on the DPEA website. So firstly, thanks to my colleague Stephanie for arranging today's meeting. She is in the background and she will step in if there are any technical issues today, which hopefully there won't be. Firstly, for the benefit of the live broadcast, can the lead participant for each party introduce yourself and those participating on your behalf? And I'll start with the appellant Craigneuk Homes to start with, please.
I'm Ms. Sharon Bow of Scottish Planning, and in the room with me I have David McKinney of Education Planning and Robert McKinnon of Craigneuk.
Perfect, thank you. And for the council?
Hi, I'm Patricia Beaton, I'm Planning Case Officer. In the room with us we have Douglas Holmes, Lee Mingus, Simon Lang, Graham Lee and Russell Todd.
Perfect, thank you. Nice to see you all. Just some housekeeping before we start. When you're not speaking, although it may not be such a big deal in this case, there's only two rooms. If we do hear any feedback or background noise, then if you're not speaking, can you put your mic off? But it might not be so bad when there's just the three of us this morning. There's no need to use electronic hands or anything like that. I'll make sure that each have a chance to participate and to comment on each of the questions and items. We will have a short break at a convenient time during the morning, and depending on progress, and I don't know how long it'll take to get through the agenda today, we will break for lunch around 12:30, 1 o'clock, at a convenient point in the agenda. And if we're going on to the afternoon, we'll also have a short break in the afternoon again, depending on progress. Now, although the session is being recorded this morning, I will be taking notes as we go along, just because they're prompts for me when I come try to up the decision, and they're kind of thinking time for me as well as we go through the evidence today. So can you please speak slowly? I may ask you to repeat something or go back on something if I haven't quite caught it, but that'll be the reason why I'm doing that. So for those that haven't been involved in a hearing session, it's a structured discussion between the parties, chaired and guided by me, and it's based on the agenda that was circulated last week. I will ask probably follow-up questions, and you can ask questions of the other through me if I think that's appropriate. But hopefully we'll get a kind of natural flow of the discussion as we go through the points. I'm not looking for opening remarks or closing submissions from any party. We will just focus on the 14 points in the agenda. Thank you to both of you for providing the list of documents that you intend to refer to. That's made it very easy for me to get documents ready and organised for this morning. That does not preclude either party referring to any other document that's before me on the case file. So please do that. You're not bound by what you sent to the case officer. You can refer to any other document that I may have, and we can pull that up respectively. So before we move on to the actual substantive part of the hearing session, are there any procedural matters or points of clarification or question that either party has? And I'll ask the appellant first. No?
Nothing.
Okay, great. And the council?
No.
Okay, so if we look at the agenda, hope we've all got that before you. The first couple of questions are dealing with the play facilities contribution. And question 1 is, where is it set out either in policy or supplementary guidance that the development of this scale requires to provide play facilities, specifically a leap? And I'll go to the council on that point first and then to the appellant.
Good morning. Russell Todd will be kind of responding on behalf of the community partnership team with regard to the play questions. Within the application, because of the number of dwellings is 47, it automatically falls within the requirement for medium development, and that covers dwellings from 30 to 99, and within a medium development that's associated to a LEAP equipped play area.
And would I be right in thinking that that comes from your minimum space standards? Is that right?
Sorry, that's correct, yeah.
And what's the status of that document?
It's current. It's slightly outdated, and we're looking to revise and update it. But that's the current document, and that's current guidance that's been provided.
And is it supplementary guidance, or is it just council guidance without the statutory status to it?
No, it's followed the Fields and Trust and the document for open space provision. It refers back to that, so that's national guidance.
And sorry, if I can come in, and in terms of status, it's been a long-term adopted kind of planning policy or council policy for play. It was included in previous local plans as, you know, formalised as part of the plan. If needs be, you know, we can maybe track down when it was approved, but it's been adopted policy for some considerable years now.
Okay, so it's adopted council policy, and I think you said there that it was previously incorporated into local development plans.
Yeah, yeah.
Okay. Appellant, do you have any comments on that?
Yeah, it's our understanding that it's not supplementary guidance. It is, as far as we're aware, additional guidance for housing developments. And it doesn't specifically outline a requirement for a LEAP, rather just 500 square metres of equipped play space is what that document outlines.
Yeah, I'm looking at the document now and I can see it's got medium developments, 30 to 90 dwellings, total minimum space, play space, 150 square metres with at least 50 square metres to be equipped play space.
But from that document, it doesn't appear there is a requirement specifically for a LEAP as outlined by community partnership.
And the council, do you have anything you want to respond to on that one?
I would say that the reference to a medium-sized development automatically refers back to a LEAP for that size. So a play area that requires at 500 square metres of play equipment falls within the LEAP parameters.
But the document that we're looking at, and correct me if I'm wrong, doesn't specify that.
So yeah, the document refers to equipped play space.
Yeah.
Yes.
So how, I suppose, just how do you track that back to automatically linking to a leap? Is there another document, or is there something that I'm kind of missing on this one?
Well, within the guidance for outdoor sports and play, as issued by Green Space for Good Scotland, which is based on the Fields and Trust guidance, the requirement for a leap is 400 square metres. So the parameters within the 500 equipped square metres falls within the leap, would be how we would interpret that.
Okay, so I've just pulled up the guidance for outdoor sport and play, and that's got, I think it's table 1.
Yeah, you've got table 1 and you've got table 2.
And from table...
So table 2 recommends the different local areas for play, local equipped areas for play, and neighbourhood areas for play.
And yes, I can see where it says locally equipped area for play, and it's got a tick at 10 to 200 dwellings.
Yeah, correct.
Okay, and this document, as far as I'm aware, is just, not say just, but is, I suppose, a national policy document, but it would be a material consideration. It's not part of the development plan.
We would consider it as part of the plan.
And on what basis would you consider it as part of the plan?
Because it's, well, historically, it's what we've always referred back to. And it's what we've based our current guidance upon, although that guidance is outdated.
Okay, the appellant.
The first instance, we were aware that a leap had become a requirement, is noted in Appeal Document F4 from Community Partnership, outlining that for 10 to 99 dwellings, a leap is required. But before that, as far as we're aware, it's not clear in the guidance whether or not it is required. The guidance that is there says equipped play space.
So what we would say is that the equipped play space is an arbitrary statement, and what we've provided with requesting a leap is the more detailed expectation that will be delivered for that.
Can I just ask the appellant, do you think that there's either policy or supplementary guidance that specifically requires a leap?
No, there's definitely no SPG. I would say it's arbitrary whether or not there's a policy within the adopted plan as well. It does say on a case-by-case basis, non-specific.
And what are you looking at there for the case-by-case basis?
Policy C1, category green infrastructure, amenity, space and play. It's page number 71 of the adopted LDP from 2022.
And that you're looking at the bottom part of that table, which is category green infrastructure, amenity, space and play.
Yeah, I think that's correct, yes.
And is that because the wording may be expected?
Yes, and contributions will be felt on a case-by-case basis.
But nowhere within that policy is reference to any SPG for play, nor is there any reference back to the minimum standards that we spoke about earlier. and that's what I expect to see it.
Okay. Council, anything you want to come back on this?
I would say it has been considered on a case-by-case basis because we've not required the on-site provision. We've not specified it to be on-site, so therefore I've asked for the contribution.
Okay.
As far as we're concerned, it's met the criteria for the play area. The space on site wasn't enough to accommodate it with the proposed layout without significant loss of number of dwellings. Therefore, we've considered the financial contribution to be the appropriate response to the requirement.
I would just add from a kind of planning perspective, just noting what the LDP says, our understanding of what that's referring to in terms of contributions or play as a reference back to the adopted council policy, which we've outlined.
And where do you think it refers back to the council policy? In this policy, or are you referring to a different policy?
Just the place standards. The place standards, in terms of minimum, medium, developments, that kind of thing. And that went to committee. If in the background, I've been able to establish when that was sent to planning committee. So it was approved for adoption back in 1999, do you believe? But it's something that we, in planning, that's what we understand, the council looks for in terms of open space and play within developments.
I would say if there's an expectation that it should have been included within the LDP and referenced there as SPG and come out as part of that bundle.
Additionally, in reference to the case-by-case basis that any contributions should be applied, we had outlined in document C for all the various parks and play spaces within the local area, and to us there is no requirement to have an additional one as a result of this development.
Just going back to the policy, and this is direct to the council, I think I suppose the bit I'm struggling with is how this policy links back to the minimum space guidelines.
Well, sorry, the minimum space guidelines is based upon the Fields and Trusts guidance. It's outdated, hence the requirement, where it states 500 square metres of equipped play space, whereas the LEAP states it's actually smaller, it's only 400 square metres of equipped play space.
But based on what I've heard, is it fair that minimum space guidance is not part of the development plan, but could potentially be a material consideration?
It would be a general consideration on all developments of this scale that meet the minimum criteria for dwelling number.
Okay. Okay, I think I've got enough on that question, unless there's any final comments either party wants to make. So, Council, do you have any final comments on this question at all?
Not at the moment.
Appellant, do you have any final comments? Okay, I will move on to question 2. And this relates to the guidance which we have actually touched on already this morning, which is the guidance for outdoor sport and play. And for leaps, which is what the contribution has been sought for, from the accessibility guidelines, it was 400 metres. And really, a few parts of this question is: are there any existing play areas within 400 metres? Any proposals for any new within 400 metres of the site? And how does that contribution, which I think goes towards the King George IV Park, which is about a mile from the site, how does that fit with that guidance?
Yeah, well, first part of that is there is no North Lanarkshire Council owned play areas or maintained play areas within 400 walking metres of this site. The closest one is nearly 800 metres away. So therefore, the play provision would be even more required within that smaller zone around the development. At the time that we initially responded to this time last year, or May last year, we were in the process of upgrading the play area at King George V Park, and we were going through the consultation process. That park has now been upgraded as part of the ongoing maintenance and upgrade programme that we run throughout the authority. So any contribution that we'd be looking would be getting spent in additional play areas. So the King George V Park is now complete and done.
So it wouldn't be used. So what would the contribution be used for? Bearing in mind there needs to be some connection to the development. Yeah,
within a mile radius of the site, as I say, the closest play area is 800 metres away. There is 7 play areas within that area, within that same circumference, and we'd be looking to use the financial contribution to upgrade and include some additional equipment in one of those play areas, which is still to be determined at this moment.
Okay, so it's a mile radius from the site, and going back to the guidance for outdoor sport and play, the walking guideline for a leap is 400 metres.
Yeah.
So I'm just wondering how that proposal for a contribution to upgrade something a mile from the site sits with that guidance.
We're restricted by the land that we've currently got available and the play areas that we've currently got available. We're not intending to be creating any new North Lanarkshire Council owned play areas because we're restricted by that. The contribution was intended when this was initially responded to a year ago to upgrade an existing play area, which has since been done. Those contributions should have been received in time for that upgrade, but that's not happened. So we're now looking at alternative sites within the ward area that would be appropriate for this contribution to be used. We're currently in discussion with a number of community groups about a couple of the sites, but that's still to be confirmed.
I suppose none of it is, even if one of these sites within that mile radius was suitable for upgrading, is it sufficiently connected to the development, bearing in mind the guidance of the 400 metre walk?
That would be why we'd be looking initially for the play area to be on site, but because of the development didn't allow for that, we're now looking out with the parameters of the guidance to achieve what we need to achieve. The initial desire would be to have play provision within that area, but because of the density of the development and the lack of available land for us to develop, then we're having to look further afield out with that 400 metres.
And out with that 400 metre would not meet the suggested walking guidelines in the guidance, would it?
Yeah, that's the reality of the situation.
And do you think there's a sufficient link between a development and a play park that's a mile away? Do you think children of that age that are going to use a leap would use that facility?
Well, if we take the King George V Park as an example, we've actually upgraded that, so that's a kind of more a destination side park. So that was the intention, that the walking distance would actually include and be in connection to the development site. But since that site has now been done, we're now looking at smaller play area developments.
Okay, I'll go to the appellant for any comments you've got on this.
I think regardless of whether or not the contribution could have been used on the King George V Park, it shouldn't have been, because it doesn't demonstrate a relationship with the site. You specifically require a leap, which has a specific requirement that it must be within 400 metres walking distance. There's no relationship or relevance to the development if you're just looking for somewhere else within a mile to upgrade. There's no benefit to the development because of that.
Okay, Councillor Jenny, response to that?
Hi, sorry. The King George V Park is the furthest location away from the site that we're looking at. All the others are, as I say, the next one's within 800 or 900 metres of the site, but we're unable to find another location closer to that due to the density of the housing that's being developed. And the initial response would have been for on-site play provision, but that's not been available because we've allowed the developer to put in the high density housing, which, if we did require an on-site provision, would have significantly reduced the number of housing that was able to be developed on that site, if at all any. So because of those restrictions, we're now looking at what the next viable option is within the council ward.
Okay. Unless there's any final comments on that question, I think again I've got enough on that one. No final. Everyone happy with that? Okay. Can we move on then to the next three questions, which are focusing on the replacement sports pitches? And really I wanted to start by having a discussion on the terms of various policies of the development plan, MPF for policy 21A, and then the local development plan policy PROTA category 4. So I'll give everyone a chance just to get those, and I'll pull them up as well. Just trying to find the local development policy. Okay, if we start with the National Planning Framework and Policy 21, and it's really paragraph A that's the most relevant here. And there's four limbs to part A. I just wonder if there's any agreement looking at this policy. So they're saying that where there's a loss of an outdoor sports facility, it will only be supported by the proposal, and it's got to say the four limbs. The first one is that it's ancillary to the principal use of the site. It's an outdoor sports facility, which wouldn't apply in this case. Involves only a minor part of the facility, would not affect its use, which again doesn't apply in this case. Meets the requirement to replace a facility, which would be lost, which isn't the case here. And the last one I think is one that's relevant, and it's just can demonstrate that there's a clear excess of provision to meet current and anticipated demand in the area, and that the site would be developed without detriment to the overall quality of provision. So it's really, are we in agreement that that's the kind of relevant policy test that we should be looking at? That's part four of policy 21A. And I just wonder if we can agree that that is the kind of policy test that I should be looking at. So I'll ask the council if that kind of accords with your understanding.
That's not what you say. I think we would also like to have a bit of discussion about part 3, because we would, and in our dealing with this application, we would just apply in Sports Scotland's requirements, and that part deals with the loss of a provision or a facility.
So part 3 of policy 21.
Yes.
So it's where the proposal meets a requirement to replace the facility which would be lost, but the proposal, I suppose, doesn't meet a requirement to replace the facility.
But maybe you would be losing a facility. I think is.
And you're thinking the requirement to replace that facility is the contribution.
Yeah.
Okay, but I suppose the proposal itself isn't meeting a requirement to replace a facility. The proposal is a housing development.
Okay, well, I said that, but again, we would refer to the section of that bit of the policy that talks about losing a facility.
Okay, so you'd look at parts 3 and 4. Okay, appellant.
We understand it. You are only required to demonstrate compliance with one criteria within Part A. And we have assessed the proposal against Part 4, and we don't agree that Part 3 applies.
And would the council accept that you only need to meet one of the tests in this part of the policy?
Again, we refer to that part of the policy, and we're losing a facility here. And when Sports Scotland responded, that was something that they indicated. We took the planning application through to decision based on the understanding that the applicant were willing to meet that as a contribution. Our usual stance would, we only take things through to determination where we have an agreement from the applicant that they're willing to meet the various developer contributions that have been identified as part of the assessment of the application. Where there's an indication that they're not willing to do that, then that may have changed our decision in this case. Our normal procedure would then be to recommend a refusal of permission where a developer has not agreed to the contributions that have been identified through the processing of the application, whether that be for play, affordable housing, education, roads, that kind of thing.
I get that that's a consideration at the time of the application, but in the context of looking whether the section 75 should be modified, would it be fair for me to consider that if one of these limbs could be satisfied, that may indicate that the contribution isn't justified?
If you refer to the document D007 Sports Scotland response, which was responded upon the appeal, in the last paragraph before the conclusion.
Sorry, first of all, which document are you going to?
Oh, sorry, it's D007. It's the Sports Scotland response dated the 14th of the 8th, 2024. On page 3 of the files.
Sorry, the reference, you say E007?
I said D, sorry.
D, sorry.
D for Delta, 007, Sports Scotland response 14.
Yeah, that's fine.
24. So, in the last paragraph before the conclusion, Sports Scotland did appreciate that the pitch was unused for a number of years, but nothing had changed since the original decision in 22, which would merit the compensation no longer being required. So, Sports Scotland are saying that they're losing a sports pitch, so they would say that there should be a replacement. The contribution that was requested was the 130,000 compensation dictated by the guidance by Sports Scotland. So therefore, our argument is that we're abiding by the statutory guidance on this, and that's why there's a requirement for it.
But I guess, so they give the initial view on the application that was decided on 2022, but since then MPF4 has been adopted, and therefore I'm just wondering, going back to that policy 21 MPF4, if one of those limbs can be satisfied, would that suggest that a contribution can't be justified?
Well, again, Sports Scotland, that was their updated response. Your question is, if, for example, under Part 4, there's but we again point to Part 3. You're losing a facility here. In recognition of that, Sports Scotland's response was clear in terms of there being a compensation element required. So
I think you'd accept. I think you'd have accepted that it wasn't being used. It hadn't been used for a considerable period of time before the application was granted. It was on the vacant and derelict land register, and the whole site seems to be part of a different policy in the local development plan, the PROM policy, which seems to be the two sides of the same coin. You've got the PROT policy and the PROM policy. So that would suggest the site was for development rather than for protection, so rather than protecting the playing field. Is that fair?
But I don't think we're asking for it to be protected. I think what we're saying is that they're taking the pitch away, so there's a statutory compensation payment for that for the pitches. So therefore, we indicated that at the outset when the first application came in. Our point on the change when the appeal was brought forward, and it's the appellant that's arguing that they don't have to pay it. We're just following the statutory guidance on what we've been told by Sport Scotland on this.
And when you refer to statutory guidance, what specifically are you kind of bundling into that?
So there's a Sport Scotland.
There's a Sport Scotland document, yeah.
There's a documentation which outlines this and explains this. Just bear with me, see if I can.
It's just so I've got. We don't need to go there. It's just so I've got a note of what you're wrapping up in that term.
Yeah.
Statutory guidance, just so I know that. That's the reason I'm just asking the question.
But that would be applicable to everyone that is taking away a sports pitch, and it's not just for housing. If our leisure teams were taking away a pitch from a sports facility and they were going to replace it, they would still have to go through Sport Scotland in order to gain permission for that. And it's not always a replacement of a pitch. Sometimes it's sporting facilities, and you can demonstrate betterment in terms of the sports facilities.
So following on your line, maybe this is moving a little bit on to the other questions. It's irrelevant whether there's sufficient provision currently, and it's irrelevant whether there's been any detriment to the overall provision. Your argument is solely that a pitch has been lost, therefore it should be replaced.
Yes. Or something that's agreeable with Sport Scotland that they would agree to. So I can give examples that recently we've been upgrading our blaze pitches in the schools because they are now not able to be used and been deemed unsafe by Sport Scotland. We're now providing things like multi-use games areas in there because it will enhance the curriculum, provide community facilities, and also we're developing some of that back into a grass space so they can use it for play provision as well within the schools. So we agree all that with Sport Scotland in advance, taking that pitch away. And they'll either say, yes, you can do that, or no, you can't do that.
Okay, before going to local development plan policy, I'll ask the appellant for their comments on what we've discussed, including MPF4 policy 21.
So in terms of policy 21, we stand by the only part that is applicable is a part 4. We don't agree that part 3 is relevant at all. In terms of Sport Scotland, their interest as a consultee, they have a vested interest in responding where the last use was an outdoor sports facility. However, to call it a facility is a bit of a reach. It is on the vacant and derelict land register. In document A5, which is the report of handling, there is no assessment against policy 21. So at that point, we have to consider whether or not that assessment was carried out properly. If the loss of this patch of grass is so detrimental to supply in the area, then the application should never have been approved in the first instance. In our document C4 and C5, we looked at open space, place efficiency and pitches with a regional sporting facility less than a mile away from the site. It is not clear to us how the loss of this patch of grass is impacting the provision or quality within the nearby area.
Given that at the time the application was granted, you accepted a contribution, what has changed since then?
I suppose the acceptance of a Section 75 doesn't mean that we agree the contribution is in line with legislation. It's just necessary to continue supply housing in line with business requirements. Section 75s do have a right to appeal, and before your permission is approved, there's little scope to object to the terms. And as noted within the council PARF, they wouldn't have approved planning permission had we objected to the terms of this.
Okay, council, any comments?
Well, I was kind of repeat what I said previously in terms of discussions around contributions. So to say effectively, well, we'll only sign a legal agreement just to get planning permission, and then we'll come back and argue about it after the event. We've always been open to discussion with developers if they are able to demonstrate that for whatever reason, with regards to our contributions, maybe it's going to impact on the viability of a project. We're open to having a discussion about that. But as far as I'm aware, there was nothing raised here. The appellant were accepting of the contribution, and we kind of moved on.
Does the council dispute anything in the appellant's play, recreation and sports sufficiency analysis that was produced?
One of the things on it was when they did the analysis of how much they could book out the spaces in both Ravenscraig and Wishaw was done in July. We were currently in the process of changing our booking system, so we had nothing on the booking system. July is also an off-peak season, so the football season is finished. The football season doesn't start till August, which all our bookings are peak period for both Wishaw and Ravenscraig, and at 90% Monday to Friday, 5 till 8, and at the weekend, and that from mid-August right through to May. So when they actually looked at the area, that's classed as off-peak. So there would be vacant slots.
Appellant, do you want to respond to that?
If you access the North Lanarkshire active app to book pitches at Ravenscraig, there are 3 outdoor sevens pitches available at any point today for a booking, apart from 8 p.m. tonight. With any pitch provision, there are going to be times where pitches aren't available, but generally that demonstrates that they are available, there's plentiful provision, and that there is no requirement for an additional one. And that was just one set looked at.
Like I said, the season finished in May, we're in June, so most teams for their training will cancel the summer because it's children's training, so most training is finished till mid-August. There will be the odd training, but majority of the summer we have booked vacancies, but it's through the season we don't. We're at 90% through our peak period.
You're at 90% through your peak periods?
Yeah, yep.
Did the appellant miss anything out in their sufficiency analysis? Like any site, any other sites or play areas or recreation sites?
No.
Is there anything before me at this point that would demonstrate anticipated demand in the future?
Can I just say as well that the pitches that they're referring to are bookable pitches. And I know that the grass pitches are open space that kids can play on. There's only one of them available at Ravenscraig within that as well. So although there's synthetic pitches and bookable space pitches at the site, they aren't available to use at all times, whereas the grass pitch could be used at given points. Other than that, there's no other sites in the area.
I think the point that we have kept repeating is that this pitch wasn't accessed, it wasn't used, and it hasn't been used for a really long time.
Well, in response to that, what we would look at is the fact that just because a pitch is unkempt, any person owning a pitch could then leave it vacant and unmaintained for a period of time and come along and say, right, well, it's not being used, but it can't be used. So it's not necessary. It's a precedent we wouldn't want to set by someone just not using and maintaining a pitch to then come along and a few years later and saying, right, well, it's not being used, so it's surplus to requirements.
I don't think that's a reasonable stance to take, to suggest that people will not maintain sites for a period of 20 years or more just to avoid a contribution. I just really don't think that's reasonable.
Well, I mean, we have to take the responses from Sport Scotland as well and look at the overall provision, but it's something that we have to take into consideration. It is a pitch that was there. It wasn't used, but it still was there.
But taking that into account, would you, 5 years ago, when looking at your overall provision, would you have counted that pitch as part of that provision?
Would you?
No.
It would show up on the pitch list.
It wouldn't show up.
It would show up on the pitch list, but obviously it wasn't being used for bookings. So it would still be identified as a pitch on all the land register that the council owns and everything that remains there. So it would stay as that. We've got pitches that we've developed recently where the council have brought forward some social housing. The council had to pay the contribution for additional facilities, which were then done at a local sports facility. So that money had to be put forward. We ended up putting in a running track at Airdrie Leisure Centre. So the council had to provide that £130,000 compensation for each of the 2 pitches that were lost. And then that money was reinvested back into sports provision within the local area. So the council's abiding by Sport Scotland statutory guidance of providing this even when they're providing their own housing.
And that was an unused pitch as well.
And that was an unused pitch. It was a blaze pitch. It was deemed unsafe and unusable by Sport Scotland.
But do you think there's a difference between that and a piece of grassland somewhere that was formerly a pitch about 15, 20 years ago?
No, because there's still
in my mind, a blaze pitch would obviously look like a pitch, albeit maybe wasn't used. Is that different to a patch of ground that historically was a pitch for, I think was for the workers that worked in the factory adjoining the site, rather than necessarily a public pitch? Is that not a different scenario?
No, because it's still a pitch and it's a blaze. It's just a different surface. It would still be open space that the kids could potentially play on out with anytime it was used as a football pitch, and that's been lost. So we would use that money to provide something else elsewhere.
Okay, Pal, do you want to respond to any of that?
I think regardless of whether it's not Sport Scotland or a consultee, we have to draw the line somewhere at when does a pitch not become a pitch. And the fact it is not being used, it was never used in any kind of official capacity. As you pointed out yourself, ma'am, it was used in conjunction with the workers. So there's no real benefit to the community of that patch of grass when it was in use. there's been no benefit for the last 20 years, it's unreasonable to suggest that they've purposely not maintained the pitch to get out of paying contribution and suggesting that that would set a precedent as an example for other landowners in the area.
Can I just check, was the site accessible by the public? I think from photos I've seen, when I went out on site, obviously the development's partly complete and ongoing. Prior to the development, from the photos I think in the documents I have, it looked like there was fencing around the pitch. Could someone have just turned up the football and got onto the land, or was it secured and locked?
It was secured and locked, and as you can see in the photos in the back of the recreation report from 2009 through to 2022, you can see the height of the grass is not suitable for playing in.
Okay, we're kind of covering questions 3, 4, and 5 here. Can we go to the local development plan?
So I think the policy is clear in suggesting that outdoor sports facilities should not be redeveloped unless there is clear overprovision or the site can be developed without detriment to overall quality of provision. And I think we have proven that throughout the process, and we don't feel that the council have answered that.
And again, you're looking at, I think, policy PROTA policy, and it's category A4, and it's the final bullet point in that table. From the council's perspective, do you agree again that one of these bullet points should be met rather than all of them?
I mean that's about like the MPF4 policy, but so a response to that would be similar. In as much as this, Sport Scotland advised that this was a scenario where compensation would be appropriate and to be secured by way of the Section 75 agreement, the appellant's agreement to meet that. Point to the last bullet point, there hasn't been a replacement strategy developed in conjunction with Sport Scotland. When we did consult them, they said that there needed to be some compensation for the loss of this facility.
And did you carry out a policy assessment against this part of the policy?
I think when this application was determined, both the LDP and MPF4 were not as advanced as.
So I meant, did you carry out a policy assessment in relation to the application to modify the section 75? Not the original, because I appreciate they weren't in place when the original application was determined. But when you considered the application to modify the section 75, I suppose what assessment did you do against this policy? Or did you just rely solely on Sport Scotland's response?
We relied on Sport Scotland response in terms of the assessing the policy. But obviously one of the things was that we didn't actually issue the delegated report formally as part of this process, because the applicant came in with a change to the overall application by also additionally wanting to remove the education as well, and then went to non-determination. So we didn't finalise the delegated report for the section 75A, and we went straight to the appeal process.
Okay, so if we're looking at this part of the policy now, do you think there is currently excess provision to meet current demand?
No.
Okay, and what detriment has the site had on the overall quality of provision in the area?
It's not.
Of course, the appellant, I'm looking at, you've obviously provided your assessment of the sufficiency of supply, which I've got, and your view from your documentation is, again, there's no detriment to the overall quality. Is that correct?
Correct.
Okay, I think I've covered this sports pitches section. I think I've got enough information on that. Before we move on to education, would everyone benefit from like a 10-minute comfort break? It would be quite taxing looking at a screen for long periods of time and listening. So if we come back at 11:15.
Perfect.
Okay, don't disconnect from the call. You can just put your cameras off and your microphones off, and then we'll come back on at 15:15. Thank you. Okay, welcome back everyone. It's now 11:15. We're going to move on to education contributions. And the first question there, I think, was just to make sure that we're focusing on the right things. And the council did put up on a slight typographical error I'd put in here. So for the next part of the agenda, my understanding is that the council looking for contributions for an extension to the local non-denominational primary school and to build a new denominational school. And again, it's a primary school rather than secondary schools. So is it fair that we should focus our discussion around the primary schools rather than secondary?
Yeah, that's correct.
It's purely just to focus the discussion. That's all I was trying to do. So that's really helpful. Okay, so question 7. I was just seeing if we could get any areas of agreement. Things around people, product ratio, school capacities, current rules, things like that. And if the council wants to start with things they think might be agreed, and then again we can narrow it into the areas of dispute.
So from my perspective, the following are agreed. Pupil product ratio is 0.3 pupils per dwelling. Catchment split is 60% non-denominational, 40% denominational. The cost per pupil is £8,769.71 for an extension. The cost is £26,000 per pupil for the cost for a new build. The calculation is based for 47 units. Based on the calculation, there would be 14 pupils generated for this site. It would be 8 non-denominational and 5 denominational, and that equates to a total contribution of £200,157.68. Can
you just give me that last figure again? Sorry.
£200,157.68.
Okay, thank you. If I come to the panel, are you happy that those points there are agreed?
Ma'am, I think I would note that there are some points of agreement, but again, it's points that we have not particularly challenged in the first instance. So we would have concerns with the status of the 0.3 ratio and that 60-40% split. We also have to have some concern over for example, the council. We're currently sitting in North Lanarkshire with one of the lowest primary school rolls since the council's inception in 1996. We're 6 pupils away from that, and yet we're being asked to make a substantial contribution.
Sorry, can I interrupt there before we get into the substantive bits? I'm just trying to see if there's things we can agree, so we don't need to go into discussion on them. So are you happy that the pupil product ratio is 0.3? I think you've based your analysis on that.
Yes, ma'am, I've worked on that 0.3.
And you're happy with that 60-40 split?
We have to accept the split that the council suggests, and we have no information otherwise.
Obviously, the appellant's position is there should be no contribution paid, and we'll come on to that. But the figures that have been provided for an extension and a new build, in principle, are those accepted?
Ma'am, we have the cost coming from the SFT, one cost not from SFT. And the problem we have is these are all indicative square metre costs. They don't particularly relate to any particular actual project that the council is taking forward at this point in time. So the actual square metre costs, they're certainly but they coming out generally based on the SFT. But the concern is that they would have to be anchored back to actual projects and actual costs.
But given the role of SFT, do you think that's a fair benchmark?
It's all that we would have to refer to.
And are you accepting that this development, based on that people product ratio, would generate 8 non-denominational pupils and 5 denominational pupils?
Ma'am, on the application of that pupil product ratio, that's certainly what the numbers would calculate out as being. But as we've already said, we are very gravely concerned that it has no reflection at all on actual birth rates and births and what we're likely to see in the forthcoming years as well. We have a ratio
we can come on to that. I'm just trying to get the points of agreement. Is there any agreement around the current capacities of the 2 schools, Berryhill and St Thomas's, that we can agree on as a starting point, and the current rules?
We've not disputed capacity or the current rules. We have to go on what the council say.
Okay, so it's just so I'm trying to establish kind of the baseline of where we are, and I think it's helpful that we can agree the capacity in the current rule based on what we've got before us. Okay.
I just asked a silly question. What are the current capacities at the moment for Berryhill and St Thomas's? I'm coming to this very, very late. I only started with chemo a few months ago, and it would be interesting if the council could confirm that for me.
So St Thomas's capacity is 292 pupils and Berryhill's capacity is 317.
It might be worth just giving the current rules for both schools as well, if you don't mind.
So the school rules at the moment are for St Thomas's we are at 232 and for Berryhill we are at 242.
And the appellant, are you happy with those figures that have been given? Oh, you're on. I think you're on mute.
That's now?
Yeah, we can hear you now.
We're back in the room. Back in the room. So I think I'm happy with those capacities. I'm currently looking at a document that the Scottish Government produced. And obviously, I'm just looking at the current capacities in terms of percentages. And I know that St Thomas's is currently sitting at, and again, just correct me if I'm wrong here, because I may well be. I think it's sitting at 79 point something or other. And Berryhill is currently sitting, and again, if I just go up to the top, Berryhill, there we go. It's currently sitting at 81.8%. So again, I just asked the question, we're currently looking at capacities and percentages, and at the moment, neither of them are hitting the 90%. So I'm just wondering if the council could maybe enlighten us on that at the moment.
Sorry, what do you want the council to enlighten you on? I missed that bit.
Just what the current capacities are sitting at in terms of, I believe we work on a ratio of 90% being required for contribution.
Okay, so you're looking for percentages. Okay.
Yeah, but none of those sites at the moment are hitting that threshold, or none of those schools are currently hitting that threshold.
And I guess you can work the percentage out by using the role and the capacity to get the percentage.
Spot on.
Just to confirm, we agree that that is the percentage of the schools at the moment, yeah.
Okay.
One query on the capacity for Berry Hill. The Scottish School Estate has that recorded as being 292.
It does.
The same as St Thomas's. So if the capacity is 317, that's an increase in capacity. It might be the Scottish School Estate does run in capacity terms 1 year in arrears, so it may be that the council have made a change more recently on that.
Yeah, that's the case. There is some shifts and changes in the capacities sometimes, depending on how the school is set up. Some of these schools have got kids with additional support needs, and the configuration of the spaces is adjusted year on year, depending on what is presented to that school. Yeah. So, but 317 and the 292 is a class space. It's basically, that's the difference between it within that. So, the figure that we're working on is 317.
317. Okay. Okay, so that's a helpful start. Sorry, yes?
I was going to ask is if that's the case, then the physical capacity of the school is clearly greater, and that means there's even more space within the school.
Potentially, but we can come on to look at that because we are going to look at the projections going forward. But yeah, I note that the capacity is slightly greater than the 292. Okay, so if we kind of covered the points of agreement, I think that's helpful. The next question is about discussion of the housing sites within the catchments for the two schools. And it's probably useful to have the document that the council submitted for query 7. And potentially the housing land audit. Okay. So it was really I was looking at the two tables at query 7, which is pulled out the housing from the housing land audit that's within the school catchments for both Berry Hill and St Thomas's, and then it's listed the site capacity and given a total. And really I was interested in looking at that in the context of the programming of the sites in the housing land audit, and really when the impact of those sites would be experienced by the school infrastructure.
Yeah, no problem at all. Obviously, as you've identified, the catchment areas for Berry Hill and St Thomas's actually sit within obviously significant house building, as you can see across the authority. Berry Hill has 13 sites, totaling just under 3,000 units, and St Thomas's has got 22 sites, which totals 4,386 units. Now, there are a lot of these sites which are programmed post 2028, but obviously the council has to approach this with a cumulative impact across the whole catchment areas. And within that, because the development at Wellington Street falls within that, there will be pressures on both these schools going forward. It looks like Berry Hill is projected to exceed capacity in 2031. It'll go to 335 pupils, which will be 115%. And St Thomas's is projected to exceed capacity by 2033, which is 107%. So these projections are based on the house-related growth in the areas in that. So the 90% occupancy threshold is used as the planning trigger as we look at the house and land audit going forward. So although they don't sit within 90% at the moment, if you look at the supplementary guidance that we provided, both Berryhill and St Thomas's had in the appendix identified that there were contributions required for these schools within it. And actually, the schools are going to face capacity pressures within the next 6 to 10 years. So within the Section 75, I think we determined that if we have not put in additional infrastructure within 10 years, then the money would be returned to the developer on that basis. So we're working on the basis that we would be looking at additional infrastructure starting for year 2031.
So I'm just looking at I think when I was looking at the housing land audit and looking at the various sites, it seemed to me that most of them, I think bar 4, were post 2034. Maybe we can go through them, or we can just pick a couple.
Sorry, there. I was just getting the sites up from where we're at. So I'm happy to take questions on the couple that you're looking at. What school in particular is it? Is it Berryhill or is it St Thomas's?
Start with Berryhill. I think when I was going through this and just looking at what sites were, programmed in, the only sites which seem to be before 2034 are sites 5, 6, 10 and 11. And everything else seemed to be post 2034.
So you say St Thomas there, sorry?
No, Berryhill, sorry.
Berryhill.
Yeah.
So on our register, it's shown as, although the sites are active on that, so these developments could come forward at any given point. Now the programming for us, I think, starts to kick in for when we see the changes around 2030 for Berryhill, when we start to see an increase on the roll based on the houses that are coming forward. So when the analysis goes through it.
Okay, maybe we should just take questions 8 and 9 together and look at, if you can tell me how you've done that analysis. That would be helpful, because obviously the tables, I'm looking at it was part of query 7, it's the last part of that one. And you've got your 2 tables.
Yeah, so the way the calculations work for it is that we obviously look at the previous builds that we've had, all right, and this is how we determine it, and that gives us an average cost of that, and then on an annual basis we're looking at the PPR for each of the for these developments. So we're looking back at historic house and land audits and developments that have came previously, and we do a calculation on that to see how many of them are then moving into our education establishments going forward. So that's where we get our 0.3, all right, and then for high school, I know we're not looking at high school, it's 0.18, in terms of how it goes forward. We then are looking at it from the number of kids that each development would come through. So it would be calculated on the number of units against the 0.03 within that, and that would determine it. Every year we also look at the split between the non-denominational and denominational schools. So every catchment area is assessed with how many kids within that catchment are actually attending non-denominational and denominational primary schools. That then is applied to the figures that we use. So we will do that once a year. We use the census data, so the school rolls that are captured on I think it's the third Wednesday of September every year. They're the figures that we would base our numbers on, and we would work as part of the calculation through that based on the previous cost times the 0.3, which gives us our cost out it. For the roll projection bit of it, in terms of the numbers, it's coming forward, like I say, from the PPR for each of these housing developments that are coming forward. So we're working that out, and then we do the NDRC split off the back of it, and that gives us the amount of kids, and they're applied into each of the primary schools.
Okay, so looking at the table you've got for, can we do Berry Hill, just because we've been speaking about Berry Hill, which is the second table there.
Yeah.
So 2024, the roll was 242, which was already said.
Yeah.
Which is there. And then I understand the migration point, the P7s leave the school, then you move all the classes up, and you add in a P1 rule. So I get the kind of migration that you're doing each year to get the figures projected for each year group. Then you've got housing columns. In this column, you've got 3. Now, is that 3 units, or is that?
No, that's 3 pupils.
3 pupils coming from housing.
Yeah, so that would be 3 pupils that would be coming from housing, that would be determined from that. So from the current housing that's in the housing land audit, we would determine that there would be 3 pupils coming. So when we reach 2026, there would be an additional 5 would then come onto it. 2027, an additional 10 would then come onto it, and it would be a cumulative approach as we go through it. So we're taking the year groups as they sit at the moment, the projection for that, and then the additional kids that are coming from new housing is shown separately in the housing column.
Okay, so is this housing figures, that's the pupils from the housing, is that based on the programming in the housing land audit?
Yeah, so that's the housing land audit that's provided to us is obviously fed into by all the developers as to when these houses are going to come forward. So we base our projections on the number of houses that are projected on the phasing of the houses in the HLA. So we can do that for up to 10 years in North Lanarkshire. So that's what we work on.
Right. So that's taking your migration class sizes. You're adding on your 3 from the housing, you get 238.
Yes, correct.
Right. So the next year you do the same process, and without housing you're at 237. Yeah. And then you've got 5 coming from housing.
Yeah.
So how does that come to 245, or are you every year adding the 3?
You've got to add the 3 on before it as well, so it's actually 8 that we're adding on. So in the housing column, it's 3 plus 5 plus the 237.
So why are you adding the 3 on again? Because they're already not in the system.
But they're not shown across the way. They're not shown across. So the numbers that are shown horizontally across there, those 3 kids haven't been added into 2026 because we don't know what stage those kids could come in at. They could come in at P1, they could come in at P7, so they could come in anywhere within that. So we've got to account for those 3 kids presenting. But when a family moves in, it's not necessarily going to be 3 primary ones that show up to the school. It could be a P1, a P4, and a P6. So we've got to base it on whatever the numbers are from the 0.3. That's why it's a projection.
Right. So when you get to, between now, with 2025 to 2034, the total number of pupils that are coming in online from new housing is the total of that column housing.
Yes.
Okay. So I'm trying to quick adding up of what that would be.
124.
124 new pupils. So how much new housing does that assume?
So it'll be times 3. So that'll be, if you divide the 124. Sorry, I'm just getting my calculator.
You're right. I'm not sure it's a times 3.
No, it's not times 3 because it's 0.3 from where it is. So it's, in terms of so the 124 is 30% of the amount of houses that would be required.
30%.
It's 30%. Yeah, so
30%.
So.
So 37.
No, it needs to be, it's multiplied by, so it's the greater number. So 124 is 30% of the amount of houses. So it's the reverse that we're trying to do here.
Yeah, I think it's the reverse calculation going up.
Yeah.
To get to.
You've just caught me in the hot with my
No, you're
maths.
fine. I've just passed the buck because.
Yeah, so basically that's the 124 is 30% of the number of housing that's due. So if you bear with me, I'll do that in the background if you want to continue, and I'll get you the number. Sorry.
No, it's fine. Let me see if I can also restart it.
Is that 110?
So based on the calculation, it's 410 houses.
410 houses.
Now, what you've got to remember here is that obviously that's within the Berry Hill catchment, and that's so 0.3. So that's 410 in that catchment between the two of the number of pupils that have been generated. There'll be more houses than that within that time period. That's only proportionate to the 0.3 for the Berry Hill kids that we're talking about. So there would be actually more kids within the catchment area because some of them would be denominational pupils also. So the houses would actually be more. We have to look at this in the round as well. So when the calculation goes in, so the way this is done, it's obviously split up, and the number of houses in each of those catchment areas. The catchment areas will intersect with each other, but they won't actually match up exactly. So, for example, St Thomas's catchment area is much bigger than what Berry Hill's catchment area is. So that's why there's a differential in terms of the number of units within that. So within the Berry Hill catchment area, there'll also be pupils which would go to the denominational primary school as well. So saying that it's right to say that 410 of those houses will attribute to the 0.3, which is the pupils who are then presenting at Berryhill, but actually there'll be more houses because there'll be additional kids that will go to St Thomas's as well.
Or do you look at another way and say that the 0.3 that you're using is 124, and actually that needs to be split between St Thomas's
No.
and Berryhill?
No, because the calculation is split already when we do it. So it's based on, so when we work out the number of units that are coming forward, the way the calculation works, it would actually produce the number of kids, and then based on the ND and denominational split, so much of them would be attributed to Berryhill, and so much of them would be attributed to St Thomas's.
Okay, and
so that's the 60-40 split we're talking about.
Okay, so if we accept the 124 pupils from the Berryhill catchment area, but
Yeah.
on understanding there might be more housing, but pupils are going to different schools. Okay, I
Yes.
get that. Okay, so we're thinking 410 houses. So when I went and did the exercise of looking through the housing land audit of the various sites for Berryhill, I could only find these 4 sites, 4, 5, 6, 10, 11, that would be built within that period to 2034.
But the houses there, so that's what's is phased up for 7 years in terms of the provision that they've provided, and then the other houses that are on that list are then so 6, 7, 10 and 11.
So no, 5, so it's 5, 6, 10, 11. And everything else seemed to be post 2034, so are not coming on stream or programmed in the housing land audit.
Sorry, I'm looking at, I'm in the background looking at a document in terms of the way the houses are phased, in terms of where it is. Sorry, and it's split. I'm just going to do it like this because that's 24. Right, so they're the 4. So the total for the 10 years that we have within this, the Caledonian Road site's 21. That's Gary Farm. That's the. Sorry, I need to do a side by side on this as well. Sorry, just bear me a second.
Are you looking at Berryhill? Sorry, just to make sure.
Yeah, I'm looking at Berryhill.
Yeah,
Sorry,
okay.
it's just because it's because of the way I've brought it up on the screen. It's also got the St Thomas's list on it as well. So just bear me a second. Just so they're matching both the. Right.
I just interrupt. Would you mind, if you would mind sharing the 4 sites that you've referenced there, 5, 6, 10 and 11?
Oh,
just
sorry,
so we know which
yes.
site. Sorry, no, you're talking numbers here and I'm a wee bit lost going, where am I going?
No, you're fine. So site 5 is 137 to 139 Craigneuk Street in Wishaw. Site 6 is Pentland Road, former St Matthew's Primary. Site 10 is your site, Wellington Street. and site 11 is land at Meadowhead Road, which was 12 sites, which I think is completed.
I agree with you there. I've had a quick look on Penland Road and the House and Land Audit, and yes, it has been programmed, but my concern here is, again, I work with Homes for Scotland doing the House and Land Audits as co-chair of the Strathclyde House Builders Committee, and we've argued that that site's non-effective because there's no planning application on it, no clear intent of development, and it's been sitting in the House and Land Audit for a number of years. So again, I would question the validity of any programming within the House and Land Audit in respect of that.
But if that's the case and they're questioning the validity of the House and Land Audit, we're obviously planning for future development that's coming forward. That's the source that we would utilise in order to determine the amount of pupils that are going to be there. So if we're getting provided with HLA and Homes for Scotland an agreement from it, so how can we question the validity of it?
And that might be one of the sites that might be getting disputed during the course of the current audit.
But we can only base it on the fact that that's the known information that we've got at that given time.
And I can hear what you're saying about that site, and I agree. I've only got the House and Land Audit, and I have to take it at face value because that's what's been approved and submitted by the council. But I
totally agree. I totally agree. But obviously, House and Land Audits at a point in time.
They are a point in time. I get that too. Yeah. But so those are the 4 sites.
Yeah.
That seem to be programmed within the next, or before 2034.
Yes.
And then everything else is post 2034.
Yes.
And then so when I added those sites together, even taking account of the one that's been built, so the pupils at site 11, which is Meadowhead Road, arguably in the system, but taking it at face value and adding all those sites up, 5, 6, 10, 11, I got 188 houses.
Yeah, but as we're coming forward, we're obviously planning for the facilities need to be ready for when these kids actually arrive on site. So, or when these houses come forward. So we're planning on the basis of that. So yeah, there is some non-effective housing as it used to be described, which was post when the application came in. There was only 7 years of effective housing on that list, from where it is, and then the rest of the houses were posted beyond 7 years. So we had to account for a percentage of those houses within years 7 to 10 coming forward, and that's where some of the additional kids have came from within the original calculations that came forward.
But looking at your projection, at 2031, you've got 27 houses for 31, 32, 33 and 34. But the programming is not supporting the number of houses you're assuming in your projections.
I just asked a silly question, and I'm sorry for asking these silly questions, but one of the sites you referenced was site number 5, is that correct?
Yes.
And that's 137 to 139 Craigneuk Street?
Yeah.
That's actually not programmed in the 2024 House and Land Audit. It's a post 2033-34 site. So again, that takes you into the... Yes, I would say that shouldn't be included in the numbers. I'm sorry, I'm just checking all these things online, so apologies.
No, that's a fair point. So that would then take us down to 144 houses from effective sites. And in that period, we're assuming 124 new pupils. So I guess my question is, are these projections overbaking the situation by assuming that amount of pupils in that period of time?
In my view, no. In terms of the way we do it, because we're looking at the HLA as a whole, and these houses these sites
surely when you're looking at the HLA as a whole, you do look at the programming as to when houses are coming stream, because that's in my mind where the impact is when the housing is occupied by someone who's got a family and the kids go to school. So that's the impact point. And I agree there's some element of future planning. I accept that from the council's perspective, that you need to be more proactive than reactive if you're trying to, you've got a strategy to provide education and everything else. So I can get there's a bit of forward future proofing in that. But for the basis of this appeal, has the projections take account of too many pupils that are not going to materialise because of the programming of the housing? So
for the 10-year period, it's shown with the phasing in the most recent HLA is 1.4 as the numbers that you've said. Obviously, the post 10 years is obviously significantly more. For Berryhill, this is only one half of the equation.
It's one half. It's one half. I accept that post 2034. Then in terms of the housing land audit, there is a considerable amount of housing to come on stream potentially.
Yeah.
Although some of those sites have been in the housing land audit for a considerable amount of time as sites. But taking it as face value, then there is the vast majority is post 2034.
For Berryhill, yes.
2034 for Berryhill. Yeah, just look at Berryhill, not St Thomas's. So given that we're looking for this development to mitigate its impact on education infrastructure, then I suppose my question is, has the number of pupils that are going to come in the system been overestimated, and therefore does this development actually have an impact?
So so for Berryhill, when it was originally calculated, the housing land audit came differently where it was effective and non-effective. It was 7 years to 10. Okay, so that's shifted. So when the original application came in, we based the 4 latter years 7 through 10, on the potential that the rest of this housing could come forward at any given point from that. So within that, what we had to do is we had to proportionate what that would be in terms of the numbers. So we've taken that and we've did the calculation, and that's what equated, if you see on Berryhill, from looking at it, from 2031 through to 2034, there's 27 pupils projected for every year coming forward from that. So that's based on the number within that. At the time when this application was made, that's how that calculation was then done.
Okay, and based on what I have now in front of me, which is the 2024 housing land audit, showing the majority of the housing being post 34.
Yeah.
Would you agree or accept that that number of pupils seems high compared to the number of housing that is programmed to be built during that period?
So
for Berryhill.
But if you take the 144, houses and you do the calculation, that works out at 29 new kids that would come from those 144 houses. We're only asking for money for 8 of those kids as part of the non-denominational, because there's already space within that school. So we've attributed.
But is there not space? Is there not space for all 29 new pupils during that period, regardless of where they come from? 144 houses using your 0.3, you're seeing 29 pupils, which I'll take as face value. Then if you look at your total projections without the housing, that would seem to suggest that those 29 pupils can be fully accommodated between now and 2034, which is when this development is going to have the impact, because the houses are built.
But again, yeah, okay, yeah.
If you disagree with me, honestly, please say if you disagree with me.
Can I just say I do actually agree with you in the numbers there? That's what I've got to in my head, based on what you've just said. I think you're spot on correct.
I'm happy for the council to get their say in and disagree, because this is your time to do that.
Based on the numbers and the way they've been calculated, and you're looking at it for the effective and non-effective, then the figures are shown as 144, not based on the way we did the calculation when it was originally done.
Okay, and accept that.
And the phasing at that point.
Okay, so then if we're accepting that that's the position based on what I had before, I mean, I accept you had different evidence before you at the time you were assessing the application, but obviously things move on. Do you accept that would result in 29 new pupils during that period? And I'm not trying to allocate where they might hit the school during that period, because I'm not that capable. So if we assume there's 29 new pupils, does the council accept that there would appear to be capacity in that school, given the capacity is 317? And it's 2034, it's sitting at 2011 plus your 29 pupils, so about 2,240.
Sorry, I don't understand that.
I've just taken that last figure, 2034, and added my 29 to it.
Okay, sorry.
Very rough and ready, sorry.
Yeah, from where we are. Yeah. Obviously, we're planning for future mitigation, and this is a housing development that's identified within that catchment area, and there's a whole number of them in there. So we will have to provide this. When the kids arrive there, they could be there for 7 years. So if the housing comes forward, then.
But given the site is mostly built, when I was on site, I would say probably 2/3 of the site was built, and probably half of it was occupied when I was out on site, maybe slightly less than half. So arguably, I know it's not science, but arguably some kids will be hitting the school infrastructure now because the housing is there. And we're not disputing today that there is capacity. It's sitting at 81.8%. So during 7 years from today, at any point will the capacity at Berry Hill be breached by this development?
Not based on the calculation you did, no.
Not based on, just except that's different to the calculation you did. Okay, and I'm going to kind of do a similar analysis for St Thomas. And this is, you've got effective and non-effective sites. And I did look at the programming to see if that represented this post-34, and generally it does. So I think the sites that are likely to come on stream according to the programming between now and 2034 would be site 1, which is land at 391 to 395 Caledonian Road. Again, tell me if I'm wrong. Site 3, which is Carry-On Farm. Site 4, which is, I can't really say that.
Go for Apple.
Thank you very much. And that may already be completed, but I'm not totally sure about that. 7, I actually couldn't find in the housing land audit, which is 406 to 420 Main Street South site. But I'm assumed, to be fair, that it is effective and it'll be before 2034. 8 is Pentland Road.
Yeah.
Already commented on. This is the St Thomas's pupil generation. 9 is Castle Hill, Weems Hill Farm East.
Yeah.
14, which is former Overton Primary School, which I think is also built. 17, which is Gothrapple Phase 2. 18, which is the site land at Wellington Street. 12, which is land at Meadow Road, which again I think has been built, and 22, which is Castle Hill, Beans Farm West.
Yeah.
So I assumed all sites, that affected sites, would be built. And that came to
1,079.
Thank you. So again, looking at your, so 1,079. So applying the pupil product ratio of 0.3. So my maths maybe isn't great, but is that 323.7 pupils?
Yeah.
Right, so we used the 0.3, but then do you take a percentage of that as being for St Thomas?
Yes. So it's 40% of that.
40% of that. Okay. So I get 129.48.
Yeah,
Sorry.
so I agree with that, sorry.
Yeah, no, it's fine. So that would be what's generated for St Thomas's up to 2034 based on the housing land audit.
Yeah.
I have a quick look at the table that you did, which I know is based on different information. I think the total number of pupils projected from housing is 164.
Yep, that's right, yeah.
Okay. Which is slightly more than what would appear to be generated from the housing land audit information.
Yeah, it's still projected to go over capacity in 2030.
Okay. Is it 2030 or is capacity, is it not, are you, when you say over capacity, are you applying the 90%?
I'm basing that on the 194 2030 and adding on the 120 main pupils.
Right, okay, sorry, I see what you've done. Okay.
So I did what you did in the last one. So I've discounted the non-effective house.
Okay.
Effectively. I think the problem here is that our projections have been done in a different HLA. And that's where all the confusion's coming this morning, and having us to do calculations as we sit here. So it's making the case very subjective now, like in terms of where it is. So we've did it at a point in time, given the information that we had known at that point in time.
And I totally get that from your perspective, and I always have to do it on the information that I have.
Yeah.
Which I accept is a different point in time. Your house, I've got the most up-to-date housing land audit, which is 2024, which maybe you didn't have at the time you did the projections. Things move on, and I've got to do on the evidence that's current at the time I do the appeal. So I accept there can sometimes be a disconnect between what you've done just because time's moved on slightly.
Yeah.
I'm just trying to make sure I understand the evidence I have that being provided by both parties to make sure I properly understand it so I can come to a decision on it.
Yeah.
Before I go to the appellant to comment on all that things we've discussed, is there anything else you want to raise in the context of these projections that we haven't touched on?
Sorry, just obviously, is it for us to respond just to where that was? Is just that obviously we did this at a point in time, from where we were. Obviously, there'll be when these houses are up. Although we've got the 0.3, the bell curve we would anticipate goes for about 10 to 13 years for the kids that are produced from this development before it then levels off. So there will be future impact on these schools from this development. Going forward, other than that, we've got nothing else to add at this point.
I would maybe just say that, I'm not sure how the council is meant to forward plan then, if it's always just a point in time. We did this and, that was the developer contributions. And if we're always going to be open to challenge in this way, it makes it very difficult for our education authority to properly plan.
And I think just to add to that, and I would have picked up this towards the end, that if they had applied at the moment into this, the high school, is because of the catchment areas that it's now in, is now shown that we're going to have to put some mitigation in for all of this housing going forward, long term, within that. So we would have probably asked for a contribution towards the high school as well at that point, which we've not asked for.
Can I ask for my benefit, how do you determine a new build versus an extension?
So it depends on the number. It depends on the number of houses. If we can extend the school any further, like depending on the school maybe landlocked, it depends on whether we've already got additional capacity within that school. So we may have already put in additional classrooms in that space. So there's no way of actually extending the school beyond the boundary that we have. So therefore, we're in a position where we need to provide the spaces. So therefore, we would be, from capacity pressures, we would have to provide a new school. An example of that at the moment that we're going through is Glenboy Primary. So we can't expand that school any further because of the way the school's designed, the space that it's in. We're having to build a new school. Similar, St Kevin's and Coatbridge is a similar scenario where it was a shared campus. We're having to decouple St Kevin's out and build a new campus for them because there's no space to expand that site, because of the house building that's coming forward in that area.
And is that the case with St Thomas's primary school?
Yeah, St Thomas's is the case. Yeah.
It can't be extended.
Yeah, so the space of the site is landlocked in each of the sites, so we wouldn't be able to put for the amount of houses. So for the amount of houses on the HLA as they come forward, it's going to we're not going to be able to cope with the demand.
Okay. It's just for my information. Okay. Right. I'll ask.
Sorry, can I just make one more point? Obviously, this particular site has been ongoing for some considerable time, and as we all noted, that a large majority of those houses have now been constructed. In terms of the Section 75, we're looking at a moment in time now where you have the most up-to-date housing land audit figures. However, some of the monies that were due to be paid to education should already have been paid, and we're kind of running behind schedule, and we're now dealing with a situation now that had some of the monies being paid when they were supposed to be paid. We might not be in this situation now, so again, it is a moment in time now, but I just would like to put forward the point that some of the contribution payments should have already have been paid.
Okay, thank you. Okay, coming to the panel now. There's been an awful lot of discussion there. So it's just for you to comment on what we've heard. Any other points you want to make?
Of course. There's one comment I want to make with regards to one of the sites you referenced, which is 406 to 420 Main Street.
Yep.
The reason you can't find it in the Housing Land Audit is because it was built out in 2021 by Trust Housing Association. But that site's already built and complete. So I think that's why you can't find it in the audit. It's been moved.
So
that would take out.
When was it complete, sorry?
Well, I'm actually looking at Google Maps, which is a wonderful tool, and it says in 2023 that site was fully built and occupied. But when I look at the Council's own planning portal, it says that planning permission was granted in 2021, and then they went through the process of discharging conditions. So I'm assuming that that site, when the planning conditions were discharged in 2022, the site was then built and occupied the following year, which would be correct. So that's why the site's not there. It's been taken out the 24 audit because it's built out and complete.
Okay, so it's not in the audit. It's not just me that can't find it.
No.
Okay.
To be fair, I looked at the audit too, and then I looked at Google Maps to see what was happening. So that's why you can't find it.
Yeah, I can't go out with any evidence. I've got the evidence before me, so that's, if I can't find it, I can't find it. But so we agree it's not in the Housing Land Audit. Okay.
But I think what we should say in that is that when they applied that originally, then these houses were counted towards the contributions towards the school, because that housing development, although it was built out in 21 to 23, is actually going to produce kids that are going to attend these schools in those catchment areas. So it is making an impact, although it's not in the Housing Land Audit now because it's complete. When we did the calculations for this, those number of houses are counted in those projections that you're looking at. So from 2024, the number of kids that are coming into that are
coming from that development too.
Yeah.
Okay.
Yeah.
What I would say is that, again, I'm looking at the relevant papers that are available for the planning application, and it doesn't look as if a financial contribution was sought. But
I don't really want to take evidence on that site because it's not before me. I haven't seen the Section 5 or anything else, so I'm kind of not interested in that site. It's not in the Housing Land Audit. I think that's as far as I need to go, but I accept the point from the council that that site will be generating pupils that are in the system.
Okay.
Okay, so any other comments you want to make on that discussion we've just had with the council?
Yes, ma'am, if I can sort of come to some of the points. If I start with some of the latter ones first, just whilst they're more fresh in memory. In the table 14 that the appellant has produced, which sets out the regulatory capacities for the various school sites.
Sorry, can I just get that? Is that in your document C6B?
Yes.
Okay, let me just-
in the appendix.
Yes, I've got that now. Yeah.
Yep. So that particular table then, it takes its current role information from the latest census. It takes the capacity from the Scottish School Estate, which runs 1 year in arrear. It takes the site areas also from the school estate, and that then has been prepared originally by the council itself. To that then, we can apply the tables in terms of capacity from the 1967 regulations, and we can see in that Berry Hill Primary could, on that site in a regulatory sense, be extended to 450 pupils, primary pupils, plus a nursery of 120. St Thomas's would have an option. You could do more than 451, which takes you all the way up to 630, but you wouldn't have any nursery pupils. So you could do 450 primary pupils and a nursery component at that school. So both schools could, according to the regulations, be extended.
How is that? Just simply looking at the site area, applying an area per pupil, and that then gives you a total number of pupils you could have on the site? Is that how you've calculated that out?
Yeah, the regulation has got a list of pupils or area, and then pupils then you can have on that particular site within that area. So this quite simply looks at the regulation and test what's permissible in terms of the regulation. So the first starting point for...
So sorry, you've taken the site area, the minimum area provided in the regulations, and that kind of gives you a theoretical amount of pupils you could have on the site.
Yeah. So that should be your starting point for doing any extension works at any school, is what can actually start with before you get down to...
Sorry, does that assume any like playground area, things like that around the school?
Yeah, there is playgrounds required within the regulations. So there's two separate tables commonly used. Well, there's a number of tables. We have one table for that deals with nursery, and that even covers things such as the nursery playground. You have an area for the main site for the school building itself, and then you have a set area for the playing field, and then you have a total site area.
So when you've calculated the number of potential pupils you could have on the site, what have you allowed in terms of outdoors?
I'm allowing for the full regulatory requirements.
Okay.
So a 450 school would have a 0.3, I think, without looking at the table, playing field requirement. So that's built into that figure.
Okay, but I suppose that's theoretical, isn't it? So it doesn't take account any issues on the site that might restrict or preclude any extension. That's a theoretical number of pupils.
Yeah, you have to then look to the school site itself and see how it's organised.
Okay.
And again, that may not mean there's issues to deal with. The theory behind the regulation is that's your developable, that's your site area that you can actually work with.
Do you mind if I come in there? Sorry, Trudy.
I don't mind at all, no.
Based on that, though, that doesn't take into account what's already on the site. That's potentially if you're starting with a clean site and then you're building out a custom built facility within that. So obviously the sites are made up of multiple things, like you say. So there's playground space allocated, there's parking allocated, there's the construction of the building. Within that, we'd have to work to the constraints of how that site is actually constructed at the moment to build out. So there's no, the way the site's designed doesn't mean that we could put an extension on the site and it would take it up to that number. It doesn't work like that, because when you're talking about the numbers we're looking at, especially for St Thomas, you've got to think about the additional dining, the additional PE space, changing, toileting, all of that. So as that gets into an extension for that amount of pupils, it would change. And with the existing building currently in its situ, that number's completely hypothetical and it's total theory. That would be from a scratch site.
Okay.
This plan, it's not really for, it's a regulation that's applied. So we will obviously have issues of, you've got a school built on a site, you then have to see how you take that forward. So, for example, with many secondary schools that have been built in the recent years, quite often they are built on the school playing fields, whilst the existing building is demolished and then it's turned back into playing fields. So you work with what you've got on the site. So that site area figure is a definitive figure that is set, and it sets what can be built on the site. If the council wishes, they can then seek an exemption from that by approaching the Scottish Government and the Inspectorate to see if they can actually do more than that. But it is it's not just something that's a theoretical, it's an actual figure, and you then have to work from that. So if that means you have to take down a part of a building, or you have to modify access in, all of those things can be considered, and typically the authority will go through that process.
We currently have a working example of that at the moment, Crescent High, where we're having to build an extension onto that because of house building. So we've had to build a number of new primary schools because of the house building, and in turn all of them are feeding into the high school. So I understand the point he's making, but it then wouldn't be just an extension we'd be building, because there's a whole reconfiguration of the school required within that. So it comes at substantial cost within that. In order to do that, if we were building from scratch, it could potentially cost us less to build that scale from there. As we're having to adapt and adjust and reconfigure, the cost then significantly increase. So therefore, again, it's apples and oranges. And also, I'd be interested to see what the metric is that's being used. Is it an SFT metric that we're working on for when you're doing your space calculation?
That calculation is simply straight from the regulation, and indeed the regulation was tested through the courts not that long ago in Borders. So the regulation is a thing, and in terms of working on a particular site, you will have to consider whether something's straightforward, whether it's more difficult, what the gains might be. So some schools you sometimes get away with a very, very simple extension. You can add 2 classrooms onto an existing run of classrooms. Sometimes it's more complex, and when it's more complex, then you have to make those other decisions about what's the overall cost benefit of doing that, and that's within how the authority is managing its school provision overall.
We appreciate that, but I don't think a tandem build would even be achievable at St Thomas's, and that's without even looking into it, just based on the site. So
I've not really addressed the school sites. The school sites are actually fairly typical urban school sites, and the authority have already indicated today that they can manage to have additional classes within the schools. So we've not actually challenged what's on that or undertaken that, but the principle here is the regulation, and the regulation says that extension is possible. We progress back. The authority mentioned one of the schools, secondary schools, needing a contribution, and the Clyde Valley High has been with 2024 an occupancy of 92%, and that's 2% above the council's threshold, and that's for the 4th year in a row. So the query I have is how does the council actually approach its 90% rule? Is it just dropped arbitrarily, or is there some other reason why that's maintained? So I have a concern as to even the evenness of the council actually approaching that issue. And we'll come to the 90% latterly as well. If I go back to the question 8, when I looked at the housing information that the council had, I used the council GIS and assumed that was a reliable source, a published source, and noted then that many of the sites are similar to Wellington Street, been unused, vacant, or derelict for many years. And when we think of these sites coming forward on the timeline that we're speaking about, which is 2034, 2031, we're going to have further ongoing school roll decline, primary school roll decline, and we're going to have falling births and falling birth rates. So by the time we get to some of these housing sites coming forward, which seems to be into the 2030s, our school rolls and the number of children per house is not going to be anything like what it currently is, unless there's a major change in government policy. The tables as well, when we looked at the tables, I noted that the Berry Hill sheet and the St Thomas's had a column for effective and active or removed. So on the sheet for the Berry Hill, it includes a column for active or removed, which is not shown on the sheet for St Thomas's, and it instead has a column for effective and non-effective. And if we link the effective and the non-effective and active across the two tables, then we find that the effective sheets that are listed at our effective sites that are listed at Berry Hill, it's the Pentland Road site, which is the former school site, we've already mentioned is queried. There's the land at Wellington Street, which is the applicant site, and there's land at Meadowhead Road, which is complete. In terms then of non-effective sites, that really applies to all of the Raven Creek site. And then we have a group of sites which is Craigneuk, Ridge Street, Shielmuir Street, 137, 139 Craigneuk Street, Lexington Street. These are all noted as being active, but in terms of a status, we don't know what that status actually is. So we therefore have 3 sites that in theory could be effective and contributing to school rolls at this point in time. And of that, we have 1 site is complete, the other site is approaching completion, and we have the St Matthew's site being something that is well, it could happen sometime in the future. It's not an active current site. If we apply the same analysis to St Thomas's sheet, then my list is very, very, very similar to the list that you had identified. And again, just matching the effectives and actives against each site. We then have that length of effective sites, one of which is not mentioned is the site NLM W1183, which is the land at Parry Lodge. 50 units. That's down as effective, but again, its active status it's not known. So in terms of effective sites, that totals up to 1,222 units, of which only 3 sites are active. And the active sites are the same sites that we've previously looked at. It's the Pentland Road, the former St Matthew's sign, it's the land at Wellington Street, and it's the land at Meadowhead Road, which is, as you've mentioned, complete. And it's also the case that St Matthew's had been a site idle since the school closed, and that was in 2010. Mm-hmm. Again, that's a reasonable length of time for anything to have taken place on that site. In terms of Query 9, then the concerns that start to come out of the projections is that we have the use of the term hybrid projection with placing requests, and that's at the top row of each forecast. And the issue then is if there's placing requests into those schools, then it would be of current concern that catchment housing and children from catchment housing is not been given a priority, because the council has a potential to reserve places for pupils from catchment housing. We also we've had that discussion about what housing was actually in the projections. It refers to
I think you've gone into mute.
Oh, sorry, apologies. What it's referencing there was the phrase where it says housing built but capped at 62 to 3 units. So unsure as to whether that's a theoretical assumption or exactly what that is. But when we looked at the tables, then if we take the St Thomas's case as an example, housing is cumulatively added so that by 2030, all housing pupils for the preceding 7 years, which is 84, is added to the forecast total for that year, which is 194. And then that gives a total projected roll of 278. So once the 7 years of housing is added up, that's the total that's actually rolled into that projected figure. And of course, one of the things when you go down to 2034, which we have mentioned as a crunch point for the authority, the 7 years of housing there adds to 128 pupils, whilst the school roll is at 185 pupils. That means that the housing equates to something like 40% of the projected school roll, which is a very surprising figure. You think if it's only coming from 60 to 60 odd units over 23 sites. And we put that in the context of housing that's been built in North Lanarkshire since 1996, which is the EP Limited Table 1 and our housing table. You have more than 30,000 houses been built across the council area, and yet the pupil rolls have declined pretty much consistently all the way through. And the catchment school rolls have also decreased by 254 pupils in primary schools and 517 pupils in secondary school. And that's from the EP Limited Table 13. make on this would be in relation to the 90% occupancy threshold for developer contributions. There's no statute which enables this. It's not in the primary legislation. It's not in the 2003 guidance. It's not in the 2014 guidance on primary schools. And the case is that the council are not in a position to apply that. If you think of placing requests in Section 28 of the Education Act, then the issue of getting one child into the school goes down to the total capacity. And that is quite a difficult process to carry through. But there's no mention of 90%. It always assumes that the capacity is fully used, and that the threshold is it's just somewhat of a nonsense. In terms of a figure to for the council to use to start to consider the need for contributions, then it would certainly be a point where the council should be starting to think about that, but it should actually only be applying it when the capacity of the school has actually been exceeded and known to be exceeded. And that means something that's imminent, not in 10 years' time.
Just on that point, I will let the council come back and comment on that, but my understanding is there is statutory guidance where the contribution trigger is where the capacity is going to go beyond 90%. So that's my understanding where the trigger is to enable the council to seek a contribution, and that's in their supplementary guidance.
At the time of the Section 75, there was no guidance. Throughout the process, they then issued the draft guidance for consultation, but throughout we have asked for information on calculations and details of it, and we never got it, which is why we're in the position we are now.
And that may be the historical position, but do you accept that the guidance does say they can trigger contributions where it goes beyond 90% capacity?
It does now.
The point, though, ma'am, is that there's no statutory basis for that. It's not contained within the Education Act. There's no statutory instrument that's been applied to actually put that into force.
Well, it's part of the supplementary guidance which the council consulted on. So for the purposes of my role, it's my understanding is it's part of the development plan. I'll let the council come back in and comment on this, but that's for me where the trigger and the hook is for allowing contributions to be sought.
Yeah, I would accept that. There's I think there's somewhat of an anomaly within that. But again, if we're dealing with circumstances where the school capacities seem to change overnight, where the housing sites that are referred to are completed and have been completed for some time, where there's a mix-up over school catchment areas, you can see then the concern that we have that everything is shifting substantially, and it's difficult then to understand exactly where the council is coming from.
Have you got any other points? Because I'm going to let the council come back and comment, and then I think we probably should break for lunch. So are you happy for me to pass over to the council? Okay, I'll let the council come in, and if you want to pick up on those comments, I might ask some questions I would like clarified, but if you want to just respond, that'd be helpful.
Okay, so I'll go back to a comment that was made around the 60 units. Basically, we look at the number of houses that's been built in each development across the year, and we actually try and proportion it. So sometimes the house builders will phase the houses at like 70 or 80 houses that's coming forward. Across the base, the average is around 50 to 60 that the each development can produce in a year from where it is. So the 60 refers to that within it. So that's just to answer that question. We accept the fact that school rolls are declining. We know that. We see that from the figures that's been put out. But what we also have to mitigate against is the fact that as house buildings come forward, they're generating extra kids within those catchments. So across the council in recent years, we've had to build 2 brand new primary schools, and we're also putting a 500 pupil extension onto a high school. So we only ever ask for money in the catchment areas where there's house building that's going to push these schools beyond the capacity of the schools. So yeah, overall across North Lanarkshire, the actual birth rates are going down. There are some schools which have excess capacity in it in terms of where it is, but we will only ever ask based on each of the catchment zones from there. And based on the HLA and the houses that are in St Thomas's and Berry Hill, there is significant developments identified that's going to come forward within those 2 catchment areas from that. In relation to the 90% trigger, as you've already stated, I won't go into that any further in terms of the guidance that we produced, but in Scottish Government they actually state that between 80% and 85% is the most effective point in a school for efficiency and learning and teaching within that. So we wait to 90%, and then obviously when we're asking, we only ever ask if the trigger's 90% and the likelihood is that all of these sites that we ask for is going to go above 100%. If we don't bring the infrastructure forward, then the developer contribution that's actually provided to the council is returned to the developer after the period of 10 years. So we don't hold that, we don't spend it in a different school, we don't use it for anything else within that. It's only ever attributed to the school that's identified within the Section 75 agreement at that point. And generally, it's a 10-year period that we would, if we take that money, we would retain that money for. If we don't bring the infrastructure forward, then that money would be returned back down. We do take a bit of grievance to saying that we should wait until it's 100% full before we build something. As you know, infrastructure takes time to put in place. So if we wait until the actual schools get to 100%, then to do an extension, it would take multiple years. To do a high school, you're talking somewhere between 3 and 5. A new build school is somewhere between 3 and 5 years that it would take to actually build that infrastructure out. So it's not unreasonable for us when we get to that 90% trigger to be forward planning in order to look at mitigating any additional pupils that are going to arrive within those schools.
Yeah, I would just add that even a very sort of in paper exercise, simple kind of solution to a schooling issue might be a porta cabin or whatever. Yeah. Even that has got a long lead-in time because the costs of these are such that it goes above what the council can do as permitted development. So, on the face of it, well, yeah, just putting a porta cabin, that can take a significant amount of time to achieve. So, just echoing what Dougie said.
Yeah, I'm just looking to see if there are any questions I wanted to pick up on. There's a point made about how you apply the 90% on the basis that I think it was Clyde Valley High is sitting at 92% and has consistently sat at 92%. I mean, I guess it's not a hard and fast 90% rule. You've got to kind of
it sits right on the threshold from where it is, and again we have to look at the phasing of the housing coming forward from that. We talk about placement requests in and out of the schools. We've got to review that as well from where it is. There's actually a significant number of pupils that have placed out of Clyde Valley High and went to a neighbouring school in Coltness. If all of those pupils decided to come back to Clyde Valley and go to their catchment school, I think it's 230 placement requests are placing out currently into the other school. So we're managing the actual estate based on that also. So we're not asking developers to contribute just because there's pupils that are in that catchment area. If they've placed into another school out with that, then they're obviously removed out of that calculation as well at that given point. So there's many different calculations in there trying to determine it.
I know
and when it sits right on the threshold where it is around 90, given intakes in year groups, that can go up and down at that point. So we're obviously using the house and land audit as the trigger point of when the houses are coming forward in order to try and plan for that. So when this development was put forward, it was sitting around that. We looked at it in terms of the spaces that are in the school at the moment, then we've not asked for a contribution for the secondary pupils at that point based on it. So,
just in your projections, how many placing requests do you assume?
on which basis, sorry?
So on your projections, you've said with placing requests. And I just wondered year on year what you assume in terms of placement requests. Like, do you get a hat 10 per year, or?
So it gets assessed on school by school basis, and it's a 3-year average for placement requests in terms of whether they're ins or outs. So for where it is, so some schools maybe there may be a school that's a desirable school to go to, which receives a lot of placement requests within that. Obviously, if there's spaces within those schools, we're legally bound to provide them with those spaces until we reach that 100% trigger point. Once the school is full, we're allowed to start refusing the placement requests for out of catchment kids, and then it could potentially go to appeal, and we have to go through the process of the appeals court in order to deal with that as it goes. So each school is different in terms of the numbers, and it changes year on year.
When in your tables where you've said, you've got the projections and it says with placement requests, you've obviously assumed that, is that placement requests both to the school and from the school?
Yes.
Yes.
Yeah. It counts both ways. Yes. So that's based on the 3-year average. Yeah.
Okay.
And obviously, because those schools are under 100% at the moment, if kids do choose to place into those schools, then we would have to accept them based on this. There's no, there isn't a refusal process until it reaches 100%. And actually, St Thomas's and Berry Hill actually receive very, very few placement requests. Berry Hill is one of the highest SIMD areas in the whole of Scotland, not just North Lanarkshire. So it doesn't receive a lot of placement requests into that school. And St Thomas's is in quite a high SIMD area as well.
Okay. Right, I propose we stop there for lunch. We've kind of covered questions up to question 9. So we've got questions 10 to 14 to come back to. If we come back at 2 o'clock, that's just over an hour for lunch, and we can deal with the last few questions then. Okay, so again, just put your cameras and microphones off, and we can come back at 2 o'clock.
Thank you.
Thank you. Okay, welcome back, everyone. Before we start with the next question on the agenda, I'll just give both parties a chance to make, if they've got any comments or clarifications they want to make, or any procedural matters they want to raise. So I'll go first to the council.
No, not at the moment.
Okay, thank you. And the appellant?
Nothing for that.
Okay, great. So we'll just go on to question 10. And this is one that I'd like the appellant to deal with first, if that's okay. And it was about this unusual stage migration that was referred to. And I just wondered what the impact of that would be if it continued, and what the evidence was that this was attributable to events in Ukraine rather than new housing.
Yeah, the migration is quite a key matter, really. And in the, I think I used the term unusual stage migration. I guess that's unusual to me, and it's unusual in the circumstances of the numbers in North Lanarkshire, given the pattern before. So, I mean, each year since 2019 has had positive migration. The longest run before was about 2002, 2004, but that was only for 3 years. And if we think of housing completions over the last 4 years, have averaged at 859 units, with positive migration averaging at 186 pupils. And that compares then to an average of 1,944 units, 1996 through, and when you have then a period of negative migration averaging at about minus 28. So there's quite a notable switch in what's happened. And then we have to sort of look towards explanations for that. Now, if we consider, again, it's what I would have to refer to is a table that we don't actually have before the inquiry. So it would be in terms of the school pupil census. But
is there anything that we do have before us that we could use?
Have a look. I certainly have the tables, obviously table 4 and table 5, which show that trend. But that's what we're looking to get somewhat of an explanation from. In terms of table 1A, again, it shows total rolls for Scotland and North Lanarkshire through to 23. And it is possible, when we look at these numbers, to see that whilst the trend has been down, you still get this effect of the downward trend slowing down. And that's where we're attracting pupils in from outside of outside of Lanarkshire and outside of just outside of Scotland. As otherwise we're having difficulties looking for reasons why. The birth information is quite telling as well, whereby that sort of overall trend has been down over a quite substantial time frame. So whether it's Scotland or North Lanarkshire, And when we then think of, and that's the same with births, or actually birth rates, which is, so that's table 7 and table 8. Both of those showing this significant decline over the time frame, and that's from data that's available, goes back to 1991. So we can see in terms of births, birth rates, table 8, that trend is down, consistently down over the time frame. And it doesn't actually, in terms of variation year by year, there's nothing that's terribly striking in that. Whereas that migration information that we're looking at is definitely something quite different. So it's not turning up in birth or birth rates. It's something that's showing in the schools themselves, and particularly in the primary schools. We don't particularly see it at the local schools. There's no real evidence for that. So there's nothing in terms of table 13. We're not seeing a notable increase over the last 3 years in terms of pupil roll. If anything, the trend is still downwards. And when we then put some of that thoughts, if we look to table 12, likewise, that's a cohort model. Shows the pupil numbers really from the S4 down to the preschool years. And that is basically a consistent downward trend. So we're seeing a lot of these trends in terms of numbers coming through are downward, but at the same time we have the numbers through migration rising, and simply recently. Within, if that is put together, then we are dealing with the circumstance where migration is compensating those trends, whether they're national or whether at local levels, in terms of births and children feeding through to schools. But at this point in time, the migration, even though it's strong, isn't actually sufficient to offset the decline that's taken place through births. What we need to see for that change to sort of stabilise the school rolls is for the births to increase and increase substantially. And likewise, there would also need to be a further uplift in migration. So you go to circumstances that are becoming more and more out of range, shall we say. And in case of the table 7, it shows on the right-hand side of that table a pupil distribution by stage, and then there's a ratio that's used just above the graphs to show the ratio of P1s to births. So for example, in 2024, there's a ratio there of 1.08, or in terms of the 2022-23 cohort, it goes up to 1.04, and yet that average ratio for all of those preceding years works out at less than 1. So there's some substantial increases taking place there. But even when we apply an average of the last 4 years to the next 4 years to derive our future P1s, we still have decline taking place in that. So even building in some of the increases that has taken place in the last few years, we're still in that position where births coming through are still not sufficient, or are not weak enough, shall we say, to be seriously affected by that migration rate.
So even if that migration rate continued, as you say, it's not offsetting that decline. So that ratio is probably going to hover around about the 1.02 level, regardless.
Yes, yeah. We need to have, quite a significant uplift in that to start to impact on that. So if we were starting to see consistent ratios in terms of our P1s of 1.06 or 7 or 8, then that obviously means there's going to be more P1s coming through. And if that then sits against that positive migration of children coming in during the session, so that's when you can start to see it's effectively you're balancing out the P7s leaving the school compared to the cohorts coming in at P1. So if they start to balance off, then you'll go first of all into school roll stability. And obviously then if you have further lift in terms of the births and then the migration, then you could see that school roll trend starting to go into positivity. That are the circumstances, but basically based on what has transpired before, that is quite an unlikely scenario. But it is something that is certainly contributing to without it at the moment, school rolls in North Lanarkshire would be much lower than they are at present. So that migration, in effect, is something that's actually quite useful for the authorities at this point in time.
And the reason it's an external factor is because of the birth rates.
Well, we can see it's an external factor because we can see it in the birth, that uplift. So there's people moving into North Lanarkshire. So something's attracting people in. It could be new housing, it could be employment, it could be all sorts of things. But we have people certainly coming in to the authority area who basically didn't give birth in the authority. That shows up as a positive factor there. And likewise, as I say, we have a very clear trend in numbers in terms of what's set out in tables 4 and to a less extent in table 5, where those trends are very clearly quite different to what has ever happened before. But at the moment, it's insufficient to actually change that overall position of school roll decline. And we can see that in terms of table 1. And in table 1, then we basically have linear trends of decline from 96 through to 2023. And in terms of total pupils by 2023, that was the lowest numbers since 1996. So even with that increase in the last few years, we still have record reductions in the school roll. So that sort of balancing act between the older ages leaving the schools and the younger groups coming through, it's the lower groups coming through that's still driving the downward decline in the school rolls.
Okay, thank you. Does the council have anything to comment on that?
Yeah, if you don't mind, just to come back in. Firstly, we don't dispute that school rolls are declining. In terms of that's very evident with the numbers that goes through there. However, we look at this on a catchment by catchment basis. So based on that, table 13 from the appellant there actually highlights the school rolls from Berry Hill and St Thomas's within that. So Berry Hill has actually seen an increase in its school roll year on year. Now, we're talking about the migration. You're right, that it could be external factors, but house building's got to be attributed to that as it goes forward, because people who live within the catchment zone are entitled to go to the catchment schools. So however they end up in the catchment, we still have to provide spaces within the schools for those pupils. going forward. And the last point that the appellant made there in relation to the decline in school rolls and how they've declined since the inception in 1996. If you go back to 2006, there's only a couple of hundred pupils of a difference between 2006 and 2023. So the figures haven't declined that much in the last 18 years across the estate. But again, we do not dispute that the school rolls have gone down, but we look on a catchment by catchment basis. We don't look at it as a North Lanarkshire wide. We appreciate there are spaces within schools across North Lanarkshire because the births and that are going down. But equally, we've got catchment areas in North Lanarkshire which has seen a huge rise in migration, house building, which has meant that we've had to build additional schools within that, even with the fact that we've got spaces in other schools across the authority.
Which I guess comes on to my next question, which is there a risk that if you look across the whole of North Lanarkshire Council primary schools collectively, you're kind of masking that impact on the catchment schools? Yeah,
entirely that's the case, because we don't ever ask for money from a developer which isn't going to support infrastructure around their development. So it's focused in and around that catchment area for that school when it goes in. So if you're looking at it as a whole for North Lanarkshire, then you're not getting a true representation of what it's actually there. It goes back to and we'll come on to it in terms of the circular test, the 5 tests, and for the necessity and need within it. But for us, it's got to be done at catchment level. It's the only way we can plan. We're legally bound to provide spaces for these kids in those catchments.
So just wonder if the appellant wants to come back on that particular point about whether looking at it at a Lanarkshire, North Lanarkshire wide basis masks the potential impacts at a catchment level.
Yeah, I would go back, ma'am, to the statutory duty that the council have, and the principal statutory duty is in Section 1 of the Education Act, and that speaks about adequate and efficient school provision for their area. It doesn't mention catchments. It refers to the area, and that's basically carried through all of the clauses of Section 1. It's the council's duty overall, and clearly you can't be efficient as an authority if you make decisions solely based on what happens at an individual school. You'll quite simply have those schools adding with capacity over time, because you're always responding to demand for places rather than adjusting that across your school estate. So there's a severe weakness in approaching dealing with schools and the need, if that's done solely on the basis of individual catchment areas.
I think it's recognised across Scotland that catchment areas are how you define the pupils that are going to schools. I think it's unfair for the appellant to be suggesting that the council should be basically moving kids around the authority, like by busing them to schools that have space at cost and such likes, in order to do that. If these developments didn't come forward, we would need to mitigate or build the spaces into these into the schools in order to provide the spaces as it stands at the moment. So the developer knew this when they came in and put their application in. They knew that the schools were identified as going to have capacity pressures going forward. They agreed to sign up to it, and now they're basically saying no. They're looking at a whole North Lanarkshire wide and saying actually the school rolls are falling. Yeah, that may be the case, but not in these catchment areas for these schools.
Does Pella want to come back on that?
Yeah, ma'am, we have in table 13. I think you've got the version which is 20 to 2023 and to 2024. The total roll in Berry Hill, St Thomas's and St Matthew's, which is that sort of catchment area for the site back in 1996, was 701 pupils. The total roll in 2024 across the now 2 schools with the closure of St Matthew's is 447. There's a very substantial decrease in school population. And if we turn to the secondary schools, Clyde Valley and St Aidan's, they had a total roll of 2,274 in 1996, and they're now down to 1,757. Those are very substantial decreases in pupil roll. And at this point in time, we know that the school roll and census date in 2024 was 228. Capacity is now 317, and we're looking to place 8 children into that school. That's less than 1 child per class. So that normal turnover of children, it's most likely that we won't even see the impact of that in terms of a role change that could be attributed to the development. And it's also, by the time we come into 2034, that's been spoke about, most of those children will already have been through the school, because we're 9 odd years away. And the children who will be remaining at school will be those who are now at preschool or about to become preschool. So it's that younger cohort who would be there at that point in time. All the other children would have left and moved on to secondary school.
Does the council want to come back in?
Yeah, just on the point of the numbers on table 13, where we're referring back to when St Matthew's was in function, the council back when they closed St Matthew's had already taken consideration of the numbers going down, and that's why St Matthew's was then closed. So if we're basing it on that, we have 2 schools and not 3 schools for the primary. So the capacity numbers have obviously reduced based on that. So we're looking historically at what was there, but we seem to be forgetting about looking forward as to what's projected in terms of the housing that's going to come forward. And that's the whole reason we're around the table, is because we are actually trying to forward plan and understand that there's going to be additional kids coming into these catchment areas that are going to have to be mitigated going forward. So yeah, Berry Hill, like we say, has seen an increase. If you look at it from there, it's continued to increase for a period of time. St Thomas's has declined slightly, but there is additional house building in St Thomas's, which is more significant than there is in the Berry Hill area from that. So in one respect, looking backwards and using that as your evidence base, for the council to do that and not to look forward, it would be negligent of us, I think, not to be planning for the future.
Okay, I'm going to move on because I think I've got enough on those points to question 12. And really, just based on what we've discussed today and the evidence that we've heard today, to a wee bit of summing up from each party as to with reference to policy C, I think CI1 of the local development plan, and the test in that policy, what requirement for new or enhanced infrastructure does the development generate, either on its own or cumulatively? So if you can deal with on its own and cumulatively, that would be useful. If you can let me know what you think the identified need is that's been demonstrated and the impact that needs to be mitigated based on kind of where we are after hearing the evidence today. I'll go with council first.
Yeah. So from your point of view, obviously, if we're reviewing it in an individual basis for this development, it's only going to generate 13 pupils, 8 and 5, I think was the number, isn't it? That's just let me check that. I think that was correct.
I think you're right. I think it was 8 and 5.
8 and 5. So from that basis, then, on an individual basis, they can go into the schools. I think from your perspective, it's the cumulative perspective that has got the impact on us, just because there's such major housing developments at Ravenscraig, and then obviously up towards the Castle Hill Farm and the Clyde Valley sites, which is got the huge development sites for St Thomas's within that. So that they're the ones that are effectively adding the majority of the kids into these schools from it, and we appreciate that. But like we say, we do this as an approach where we look at all of the housing developments, and we've got to proportionate that. So each development, like I say, is actually afforded space that's in the schools, so it's balanced out across the numbers, and then we only charge on a pro rata basis of what's left, based on each of the size of the developments. I think we said earlier it was like this development would produce 29 kids. I think it was when we did the calculation.
It was something like that, yeah.
Yeah, and off the basis of that, we're asking for 0.3 of that, effectively.
Okay, so no individual impact, but cumulatively we look at all development that's ongoing in the area and to allow the council to forward plan. That's when the contribution becomes necessary.
Yeah, and that's got to be the council does it, because if we do it the other way and we do it individually, it would mean that one development would then be accountable for all of the infrastructure given the time that they apply for that. We work on the house and land audit, which is given us 10 years, and if we look back to when this was calculated, the house and land audit only provided us the effective housing for 7 years, and the rest of the houses were wrapped up in years 8 through 10. From where, and that's why there was those 20-20-20 and the 27-27-27, because when the calculation was done at that time, we didn't know when those developments were going to come within it, but we had to attribute it to a potential that they could come in those final 3 years of the house and land audit.
Okay, the appellant.
And in terms of the impact, ma'am, I would simply revert to the fact that at present there is capacity at Berry Hills Primary School, and also at St Thomas's, and also in the secondary schools. So the impact on school by school, we've said is likely to be less than 1 child per class. That impact is going to reduce over time, and by the time that some of these long-term housing sites come forward, we're going to be in a position where our school rolls are still likely to be in decline, including at the catchment schools themselves, where the total roll at St Thomas's has declined since 2016. So we're in that period. We have school roll decline. It's happening at the local schools. So that is the position as we see it for the schools. We have another matter here as well.
I was just going to say, in addition to the policy, it's clear it will be on a case-by-case basis. And we submitted document 7, which is an appeal in North Lanarkshire relating to education contributions. And the summary, I guess, is that the case-by-case basis is important, and the reporter found concerns with the 0.3 pupil product ratio and found it didn't relate to the specific impact of an individual development on educational infrastructure in the area it's situated. We'd further discuss this in document C2, and it's also included in document G3, which is the Homes for Scotland's consultation response, essentially finding it as a tariff which doesn't relate to the development. And as such, it doesn't meet the tests.
Okay, I thought your position was that you accepted the pupil product ratio, but actually, even when applying that ratio, there's no impact on the schools.
I think either way, we don't have a choice but to accept it, but it's just highlighting the flaws with that methodology.
But is your primary case the fact that there's just no impact from the development? Sorry, I didn't catch that.
Yeah.
Okay. Lanarkshire Council, do you want to come back in with any comments?
I find it hard that they're disputing the 0.3. We've obviously not got anything to present here just because it's not been submitted previously, but we have evidence that some housing developments are producing up to 0.5. But in the round across the whole authority, and we look at all the developments, because obviously there's such variety in the types of housing developments that come forward, from 2-bedroom flats to 5-bedroom houses and all the way through it, that generally when it balances itself out across the authority, the 0.3 is the figure that we use. As part of our supplementary guidance, that's the number that's published in there, and within that we say that we'll review that annually when we do it. So I dispute that fact if they're now going against the 0.3.
Well, I don't want to come back on that point. I mean, I think the position I understood was that you weren't disputing the 0.3. It was the fact that your development has no impact.
We'll just have we check it one of the reports for a moment.
We are willing to accept the 0.3 pupil product ratio. We do think there are issues with it, but we do fully agree that our development has no impact.
Okay, that's helpful, thank you. So I think I've got enough on that question. So really there's 2 points now for concluding matters. And you can roll them together if you want, or actually maybe just do it separately. So the first point was, what has changed since the Section 75 agreement was entered into? And I'd like the appellant to deal with that point first, please.
In summary, since the Section 75 was entered, North Lanarkshire then issued draft supplementary guidance for education. Also beyond that is when we were made aware of the LEAP and the requirement for the LEAP and where that money was going to be spent. Additionally, we then, upon submitting this appeal, sought to change our contribution to remove education in its entirety, given the new evidence that we had and had submitted to North Lanarkshire. And it was only as late as the council's response to the appeal that we were made aware of the miscalculation for the education contributions for the site next door. And I think that is a summary of our position.
And has anything changed in respect of the playing field contribution? Any changed circumstance there or new evidence?
Not that I'm aware of. It may be that Ravenscraig Regional Sport opened after, but I'm not certain.
Okay, thank you. North Lanarkshire Council?
Okay, just taking the point about the error and the miscalculation for the other development within that, that actually went in the appellant's favour, because should that mistake not have been made, and we fully accept that there was an error in that, we would have asked for contributions for St Thomas's as part of that development site as well, within it. So we've now moved on from that because the error came in our point. Obviously, what changed since our calculations is that the HLA was assessed on the 7-year basis, as we spoke, and the subsequent housing was projected across the remaining years up to 10 within that, and we proportionated that back. So that's where we got the additional housing within that. Obviously, the developments began, and there's obviously so it began after the plan permission, and it triggered the obligations on the agreement which have failed to be paid at this point. We clarified the catchment boundaries. Again, that relates back to the other part. And it's maybe just worth noting as well that back in 2021, the Education Authority within North Lanarkshire actually did a statutory education consultation to bring forward a new denominational and non-denominational primary school within Ravenscraig, and they actually cited out in that a new catchment boundary, which this housing development would have sat within, which, if the application was being made at this time, because the council is now it's now been approved to take that school forward, we'd have been asking for contributions for a new build for both denominational and denominational because of the catchment boundary that it sits in from that. So as well as the secondary contribution that goes forward. But because we're working on the point in time when the application was made and not now, and the evidence that's available at the moment, our position obviously is that we're asking for the contribution that has been agreed to by the appellant in the previous section 75 that was actually signed at that point. I don't know if there's anything for the planning authority they want to add to that.
No, I don't think so. You've summed it up.
Okay, that's helpful. Does the appellant have any final comments, or are you happy with the position?
I think at the point in time, we were told that there were different catchments between this site and the site next door. There was no guidance and any requests from anyone in relation to contributions. We weren't met with the level of detail that you would expect. And I just think that's worth pointing out. The original preference for payment for these contributions was a Section 69 agreement, which we know doesn't have a right of appeal. So it's difficult to understand why that would be the preference when, and we'd be expected to accept that when there's no transparency in the process.
On that, I would say that during the application process, when there is a developer contribution, we advise the applicant of that and ask them whether or not they would be and would agree to sign up to those developer contribution, and what type of agreement would they be looking for, would they find acceptable. And initially, yes, it was a 69 agreement, but it was the applicant who then changed and asked for a 75 agreement. We would be happy to have signed up to that 69 agreement, but because the applicant had asked for the 75 agreement, that's what eventually was signed up to and agreed in full.
Can I just also add something, just one last thing there, just on the basis that we only found out about the catchment areas. The school catchment areas are actually available online. They're in the public domain. Anybody can find them, so a developer can go and look at their site and they can check to see which schools are affected by the development at any given point. Parents use it all the time when they're buying new houses to go online and look to see which school catchments their kids would fall into from there. So to say that they only found out that there was an error by the council, we appreciate that, we put that back to them. So at that point, if they were surprised by that, they would have raised that. But again, it was in the appellant's favour, where we didn't ask for a contribution, whereas at St Thomas's we would have asked for a contribution within that. So it's unfair to say that they didn't know that it was in that.
Okay, I'm going to move on and just deal with the last question. And again, I'd like each party, I'll start with the council this time, just to comment on the extent to which the three contributions we're speaking about, the play contribution, sport pitches contribution, and the education contribution meets the test in the circular.
I think as Dougie has said, a couple of times, the council's overall approach to developer contributions is just to seek them when they're required. That's the only time we ever get into discussions with developers about the need to mitigate against their particular development. It's always with reference to their development and the impact of their development, whether it be individually or as part of a cumulative impact. So, we've routinely have discussions with developers in terms of affordable housing, in terms of off-site play, and obviously, as we're discussing today, with education contributions. But our start and finishing point is always with reference to the test. That's the only time we look for contributions where we feel it's justified by reference to the test.
And can you just summarise how you feel they meet the tests?
So I can pick up that in terms of the necessary to make development acceptable. So if education is obviously required to address the projected capacity exceedance at the schools, or play is required due to the absence of on-site provision. So they're not providing play provision at the site. So therefore the contribution request is obviously a mitigation for that, which has allowed them to build more houses on that site and make it more dense. And then the community facilities are required to mitigate the loss of the former sports pitch in line with the Sports Scotland guidance. Within that, in relation to the planning purpose, the contributions support the infrastructure provision aligned with the LDP and the NPF4. Related to the development, the contributions are directly linked to the scale and impact to the site. So we're not asking for every pupil, we're asking for a proportion of those pupils that's coming forward. Fair and reasonably related to the scale and kind. The calculations are based on standardised cost per pupil and per unit metrics using a consistent methodology across the authority, and it's reasonable in all other aspects. So the contributions are proportionate, time limited and clearly defined in the Section 75 agreement, which the appellant agreed to at the outset.
Okay, thank you. Appellant?
So, I mean, as Circular 312 is clear, it has to meet all 5 tests. So without having to repeat myself, I'll just do one area of each contribution, if that's okay. So for the community facilities obligation, which is the replacement sports pitch, we don't feel that it is necessary, as noted in paragraph 3.9 of our appeal statement. North Lanarkshire Council have not demonstrated that the development of this site creates additional demand for a sports pitch. So that's that one. For the play contribution, it fails the relationship to the proposed development test. As the council have noted, any contribution would be spent out with 400 metres, more likely to be 800, so it cannot demonstrate a relationship to the proposals. In regards to education, we don't feel that it is necessary for this development to mitigate any impact on education. There is provision and we are in agreement that this can be accommodated.
Okay. So if I'm quite happy to understand both your positions. We've gone through all the questions. I think I have now got enough to allow me to go on and write the decision. Is there any concluding comments from either party? Council?
No, we don't.
Appellant?
Nothing from us.
Okay. At this point, I don't anticipate requiring anything further to allow me to write my decision. The target date is currently the 19th of September, and the decision will be issued by the case officer, I think, before that date. But if you have any queries in the meantime, then do get in touch with the case officer, Rebecca, and she will be able to assist you. But thank you all for your contributions today. It's been really helpful from my perspective, which is kind of the benefit of a hearing. You could do it quite concisely, you can ask follow-up questions rather than doing it all in writing. So it's really beneficial to me to have the hearing today. So thank you all for taking part and for your contributions. And you're all free to leave. the call.
Thank you.
Thank
Thanks
you.
for your time. Thank you.
Thank you.
Thank you.
Okay.